Technology and our Center for E-Commerce. We have two fantastic speakers here with us today. Lotte Teteman, partner at Baker McKenzie, and Ian Ballin, who's a shareholder at Greenberg Traurig, and also executive director of our Center for E-Commerce. Both are really leading technology lawyers in California, and they will talk with us about California privacy law and best practices for internet, mobile, and e-commerce companies. So Lotte is, as I said, is a partner at Baker McKenzie. He also is a teacher. He teaches at UC Berkeley, where he teaches privacy law, as well as Stanford Law School. And he's a prolific author. He's written over 100 articles on technology law-related topic, and over five books on tech law topics. And last couple of books, I think, were mostly focused on privacy, California privacy, as well as privacy rules around the world. Ian Ballin is a litigator and co-chair of Greenberg Traurig's global IP and technology practice. He's counseling companies on internet and mobile related litigation, including data privacy and security breaches, behavioral advertising, and TCPA class action suits. He's also the author of the Internet Law E-commerce, the E-commerce and Internet Law treatise, and he also wrote the handbook on the CAN-SPAM Act. So aside from that, he's also the co-chair of our e-commerce best practices conference, and that's just to give a quick plug for that conference. That's on June 12th. So anyways, without further ado, I'll just turn it over to our panelists. So please join me in welcoming our speakers.
Thanks so much, Roland. I think the microphone is on. We were planning of running around here and having all kinds of visuals, but since we're in Silicon Valley, we have to do this a little more manual and cuddle up here together to operate this manually.
It turns out you need to have batteries that work for a clicker. This was an important revelation.
When you look at the California flag here, you see this evil-looking brown bear, and in reality, our bears look very cuddly and cute that we have here left, and they found the way to the cover of the first edition, and the second edition looks a little more aggressive because we've had a lot of litigation here in recent years, and that is also covered, you see, in the 5 volumes of Ian's treatise, which fills the shelves in our San Francisco, in our Palo Alto office, and is often referred to with lots of updates, not just on privacy, but increasingly also on privacy law.
Yes, brevity is not my strong suit, so it's now 5 volumes.
When we think of California law, often we appear at Stanford and present on international laws. We forget our home state here. When I came to California, we were just thinking about our starts here. Ian came from Canada, I came from Europe. 20 years ago, there wasn't that much law, and we have tons of law here now. And it's quite interesting, I think, for other countries also to take a look at how much of these laws apply to other jurisdictions. Many of the California privacy laws have global applications, say specifically in the statute, any company worldwide collecting personal data from somebody in California and will have to comply with these laws and can be relatively easily hauled in courts here. Probably less significant to the local audience, but something that we point out when we speak at the East Coast or, say, in other jurisdictions. There's some limitations on California jurisdiction under federal law, Dormant Commerce Clause, but there's really nothing internationally that would stop any country to legislate whatever they want, and the U.S. has certainly, after solving all domestic problems, started to regulating trade with Cuba and other things that is an interest in. And in the privacy area, we will see that a lot of the statutes that we have now have applicability and easily also enforceability with ties to California for other countries. When we started, a lot was best practices. Trustee was a nonprofit company that tried to set some standards on what should be in a privacy policy. But we now have tons of laws. We have in the Civil Code, I think I have my copy over there, At least in the civil codes, we have already 10 different definitions of what personally identifiable data means. And that is just one of many different statutes. And so in this book that we have up here, I try to cover the California law from A to Z. I think Ian took a different approach in the treaties.
Yeah, and I apologize also. I have to use this 1970s era microphone because we only had one mobile mic, and I lost the coin flip on that. But yeah, in my treatise, I don't cover all the letters. I only cover the ones that I like. So A to Z, you have to go to Lothar.
We try to cover with that on every letter what is covered, who has to comply with this, and what happens if you don't comply with it for every California privacy law in there. And there's some key feature what it is in terms of California law. We, for the most part, have in every statute an expectation of privacy is one of the conditions. Sometimes it says specifically in there, sometimes it has something about confidential and so on. And these can be destroyed with the notice. In the employment area, for example, letter E that we won't cover any further today, there isn't that much that an employer cannot get out of by giving a notice and saying what they're doing, because then nobody has a reasonable expectation anymore. We have increasingly data security rules, very specifically. Every year, Sacramento is adding a few. And we have detailed prohibitions and regulations and dozens of sector-specific laws. And the California law isn't just made in California, Ian, right?
Right. There actually are a couple of interesting phenomena. One is that California law can be adjudicated really almost anywhere. And so you have courts in other parts of the country construing California law. But as a practical matter, California law tends to be broader and more liberal in orientation than the laws of a lot of other states. And a judge in New York, for example, applying California law, often will apply California law more consistently with New York law, narrowly, than a judge in California. But we also see the opposite, which is that people are coming now from around the country to litigate other state laws in California because of the perception that California judges and juries are more favorable to plaintiffs in internet and mobile type cases than elsewhere. For example, here in the Northern District of California, there's a lawsuit pending involving the Illinois Biometric Privacy Act, which is a statute that a lot of privacy lawyers, plaintiffs' lawyers, have tried to litigate. It hasn't gotten very far in lawsuits in Illinois, but it has here in the Northern District of California. So when we talk about California law, from a litigation perspective, really, there's this dual bleeding where our statutes are construed elsewhere sometimes, and increasingly we're seeing other state laws being litigated here in California because plaintiffs' lawyers want to have the favorable juries and judges.
There's also a number of things that California privacy is not compared to other jurisdictions. We don't have one omnibus statute. We don't have a prohibition of data processing as in the General Data Protection Regulation in Europe. We have no minimization requirements. It's generally okay to store as much data as you legitimately need for your business, so long as you notify people about it. We don't have a data protection authority here. We have a task force at the Attorney General, but not a special authority. There's no registrations, no filings, no data protection officers that anybody has to appoint under California law. The federal HIPAA has a requirement for covered entities to appoint a data privacy officer and a security officer, even for business associates, but there's nothing in any California law that specifically requires that. We also don't have any restrictions on international transfers. So all the things that companies have to deal with in order to transfer personal data from Europe to California does not apply reciprocally, and data can be transferred from California elsewhere so long as the California laws are met. So a lot of things that we don't have as a bureaucracy, but that should not mean that there aren't a lot of different substantive provisions that companies should focus on.
Yeah, and also, frankly, we have a disproportionate share of the data privacy litigation, not the security breach litigation. That's spread out throughout the country, but data privacy cases, which are cases brought against companies alleging that a company failed to meet a particular standard, are brought in California to a disproportionate extent, more so in the Ninth Circuit than any other circuit, and more so in California than any other state.
So the first part of this presentation will go through some of the A to Z. We won't cover every letter here today, but we'll try to get through some. Only the good ones?
Only the good letters.
But we'll try to cover some. We invite you all to ask questions. We don't have to cover every particular letter. So if you have something specifically on your mind you want to ask about, please do ask away. And towards the end, we'll also have a few slides on practical recommendations, drafting tips, and so on that may be of interest. We start with the letter A. One peculiar aspect of California is that 1972, the people of California, with the proposition, added a right to privacy to the Constitution, and that has been interpreted by the courts to apply not just against state actors on a federal level, but also against private actors. The statement is really "and privacy," if you look at the verbiage, but the impact in litigation cannot be underestimated.
Yeah, I mean, California is the only state that has a state constitution that protects privacy in a way that A, creates a cause of action for lawsuits, including class action suits, and B, applies not just to state activity, but to individual activity. And so it's typically one of a number of claims that gets raised in litigation in California.
And just the mere fact that it is raised, and it is somewhat alien to courts also in other U.S. states, has led to a difficulty in litigation just to get rid of cases where a reasonable jury could have agreed that with those two words, and privacy, perhaps some placement of cookies or other mechanism that a company has deployed to collect personal data may not be reasonable. And so it has become a relevant factor in privacy litigation. I would say if you look through all the different cases, and there are quite a few now, more often than not it is ultimately dismissed. It does not add another legal standard. All these other California laws are more specific and detailed, but it adds another thing that a plaintiff can throw in there where a judge may be hesitant to dismiss on summary judgment.
Yeah, and I'll say, you know, as a litigator who defends companies in these type of cases, I'm less concerned about this particular provision because it does have a reasonableness component. There has to be a violation of a reasonable expectation of privacy, and I think it's been construed reasonably well. The statutes that I find potentially more concerning, California Consumer Legal Remedies Act and 17200, the unfair competition statute, because those are very broad and those are nebulous. And the way that plaintiffs' lawyers often look at these cases is they'll identify a practice or a technology, they'll bring a complaint, they'll add 10 to 13 causes of action, and their hope is that they just get something through a motion to dismiss so they can get into discovery and move for class certification. And it's oftentimes these state law claims, particularly the California claims, or even these other claims like the Illinois biometric claims asserted in California, that get the plaintiffs over the hump. We'll talk about some of the differences between federal and state law, but it is often the California claims that give the plaintiffs that hook.
From a practical perspective, I think companies in California, as they plan their data processing, data collection practices, should keep in mind that even if they comply with these very prescriptive statutes, there could still be a challenge launched under this broader law. And so keeping in mind that reasonable privacy expectations could be found, companies are advised to be even more clear on putting out disclosures of what exactly they do with data, beyond even the specific statutes. Skipping B, going to C is computer interference. We have a body of law that isn't really specifically intended to protect privacy. This is a trespass law. It protects computers from unauthorized access and criminalizes any access to a computer without or exceeding authorization, which in some cases have found to be the case if somebody accesses a website and lies on registration in MySpace about their age or name, they're exceeding the authorization in the website terms and conditions of MySpace, and whatever else they do is then a crime. We have found this in the employment area where a lot of employers asserted somebody's doing something bad against company policy, exceeding authorization, and then being criminalized or having civil claims here. And there's a long list of cases. When we just went over this before, you noticed that the California statute even has a separate prong.
Right. And did you want to go through those? Or you want me to
I
skip
just
ahead?
thought you
Skip
wanted
ahead.
to mention the California specific prohibition that is not just on unauthorized access, but also on authorized access, but then exceeding authorization with respect to taking materials.
Oh yes, actually the California statute is a little bit different, and so there are instances. The federal law, the Computer Fraud and Abuse Act, deals with access to a computer. The state law is focused more on the taking. So if you actually just browse, that may not be enough under the California law, but it is under the federal law. And it's a reminder that there are a lot of different standards. From a transactional perspective, you need to comply with everything. The Computer Fraud and Abuse Act is another good example of that, where there's actually the law in California under the Computer Fraud and Abuse Act is more favorable to companies because it's a criminal statute. And the Ninth Circuit in the U.S. v. Nozal case has construed the concept of without authorization somewhat narrowly. It's interesting when you have these criminal statutes that also have civil corollaries, it's often the criminal interpretations that end up helping or hurting parties in the civil context. But what you had in U.S. v. Nozal, you had someone here in Palo Alto who went from an executive search firm to start his own company. And he thought it would be a great business development opportunity if he continued to access the computer network of his former employer and see all of their private information. It turned out to be very helpful for him, but it also got him arrested, and he was charged with a crime. So this went up to the Ninth Circuit for exceeding authorized access because he had a password, but the password was to let him use the computer when he was an employee, not to go in and steal things. And then Chief Judge Kaczynski, in an en banc decision, said that exceeding authorized access cannot be judged by a use restriction, like terms of use or an employment policy, because it's a criminal statute. And criminal crimes need to be defined clearly. And this was not defined clearly because he could access the computer, it would be authorized, and then once he starts to do improper things, then suddenly it's without authorization. There's a split of authority, though. The Fourth Circuit agrees with the Ninth Circuit. Other circuits don't. And so, again, even though in California, you may not be able to rely on use restrictions because they do apply in other places, where an individual or company gets sued can make a big difference. This is really true, I think, from A to Z when you're dealing with privacy litigation. There are statutes where different circuits have different approaches. There are state laws where one state is different than the other. As a privacy practitioner, you have to anticipate all of these. These kind of issues come up not just in the privacy, but also in the screen scraping area. The Nozal case, incidentally, came back up to the Ninth Circuit again in 2016 because he won the case the first time. The court said, you cannot be convicted of a crime for exceeding authorized access because it's based on a use restriction and that's too vague. Went back down for a trial, and what happened was the government said, fine, we're not going to litigate exceeding authorized access. We're going to litigate this as an unauthorized access claim. Once you were no longer employed, you had no access. And on that basis, they got a jury conviction. It was affirmed on appeal. And that's typically what you're seeing now. Facebook, for example, in the Power Ventures case, also did the same thing. That was a case that started as a terms of use violation. You had a company that was accessing personal information on Facebook to invite people to join this competing social network. If you were a member of both, you could authorize Power Ventures to access your address book on Facebook and contact people. And it started as a use restriction type case. They violated terms of use. But what Facebook did was they sent a cease and desist letter saying, you are not allowed to access our site at all. And that's why the Ninth Circuit said, yeah, it could be a use restriction case. But once they sent a cease and desist letter, it's all over. It's unauthorized access. And that's really an important thing to keep in mind for your practices. If you're trying to prevent other people from accessing things in the Ninth Circuit, in California, send a cease and desist letter, then it becomes a no access case. And these distinctions don't make a difference.
I think also to think about a few other things in the privacy protection program as much as in your trade secret protection program is how you define your terms of use, how clear you are, which may be contractual covenants and which are really defining the access from a property perspective, and then ultimately also with the Computer Fraud and Abuse Act. If you say everything, every violation of the terms of use would be invalid, then the courts will likely not enforce that. But if you're very specific and set additional prohibitions and people violate those, you will be more easily able to defend your computers. Think about it broader as in web scraping, information gathering programs. A lot of companies are doing that, automated because it's easier. Think about how you do analyze other companies' terms of use, whether it's worth taking a look, whether you program your robots in a way that they look for no robot scripts and respect those. And similarly, with your own data, think about which ones you're willing to open up to robots, say to search indexing and other things, and which areas you want to put a more narrow protection on that. That should be part of a data security program, and it should be designed also with this law in mind. Another thing is these bounty programs where you encourage security researcher to take a look at your penetration protections, intrusion protections. If you invite them to come in and hack and you're not so clear about it, maybe you lose protection under Computer Fraud and Abuse Act because you actually gave authorization, you actually challenged people and said, hey, try this out, which could expose data, possibly create a data security breach that you invited with your program.
And this is the California law, which is a little bit different. The Computer Fraud and Abuse Act prohibits unauthorized access or exceeding authorized access. The California law merely requires knowing access, but then it penalizes if there's knowing access and then intentional conduct in terms of extracting information, then it becomes actionable. So it's a little bit different. And again, it's one of these things you see sort of parallel state laws that are just slightly different, and you have to pay attention to how they're different and whether it impacts your business.
D for data security.
D for data security.
So we have a relatively broad statute here. It's a little older than, for example, the Massachusetts regulations, which go into more detail. And it just lists reasonable security procedures. We have more specific rules in more specific statutes, sector-specific statutes. The latest that was added was on automated license plate scans, technologies that the police uses, that also some private security companies use to identify who's going in and out of a gate or so. There are very specific rules in there. We have them in federal laws, we have them in HIPAA, we have them in GLB and other areas where there's very specific standards now sitting in the statutes. Few are technology specific, so we don't see you have to use 128-bit encryption or so, but there are definitions for encryption. And we do have the very first data security breach notification statute here, made in California, 2002. Always like to point that out when we go to Europe, that it's taken them till 2018 to have a data security breach notification statute. Ours was fairly simple at the beginning in that it just required notification. There was no sanction for the breach as such. But in this latest update, there is now a particular cause of action for a breach of databases that contain automated license plate information. And I think that's a trend, so we can expect every time the statute will be renewed, there's not only going to be a penalty for failure to notify, but additionally, there may be sanctions for suffering a breach in the first place, not meeting the security obligations.
And California also now requires plain English, which is sometimes a challenge for lawyers in writing these notices. But there's forms.
We even have a sample form, so if you use that form or use the headers, then you're supposed to, or you can rely on the fact that you're deemed to comply. One problem exists that some of the other states have somewhat conflicting notices. I would still recommend to clients, particularly in a crisis mode, to just go with that form. And I have not seen anybody have repercussions. For example, the California statute requires that there has to be an explanation on what happened on the breach. And then a few other states say you can't tell anybody because it may be just unhelpful for law enforcement investigations and so on. But at the end of the day, I think because the disclosure is required in California, the effort that it would be required to draft a different notice for Massachusetts for California is usually not something that companies have time for. So it's probably okay to go with the California notice format worldwide is still my sense.
Well, I would say for bigger companies, I mean, the last number of breaches I've had, I have not been able to use a single letter. That in order to, because of this duality where some jurisdictions require you to say what you know for consumer protection reasons, and others require you to not disclose what you know so that you don't jeopardize a police investigation. That you do, if you're a bigger company and you're trying to comply with all the laws, you can't get it all in one letter.
The timing, we don't have a particular number of days in our statute. Other states have typically something around 30 days. Europe wants to top it with 72 hours. That'll be as of May 2018. But until then, we will have a little more time here. My sense, it is very difficult to do a notification properly, an investigation, say the right things. And more cases, several companies are involved. And if you say something after 72 hours that throws one of your vendors under the bus and takes 20% of their share price the next day, that could have far greater repercussions than as if a consumer has to wait another day with a more meaningful notice.
Yeah, I think that's very important. I've handled a lot of security breaches, many of which end up in litigation. And I can't think of one where what the company thought happened in the first certainly 48 hours, but maybe 72 hours, probably 72 hours as well, actually turned out to be a full, complete, accurate statement of what really happened. And so if you have to provide notice in 72 hours, the likelihood is you're going to provide inaccurate notice. Now in Europe, maybe that's not as much of a problem because it's not as litigious. But here, class action lawyers will hit you in both directions. If you wait too long, then they'll sue you because the delay in giving notice caused some injury. And if you provide a notice too quickly and it's wrong, you may end up having the opposite problem, which is you've said something wrong. There's a major case involving P.F. Chang's where they came out initially and said this affected all of our restaurants, and then about a week later they determined it was only a small number of restaurants. The Seventh Circuit allowed a lawsuit to go forward by patrons of restaurants that they had then concluded had not been subject to the breach because of this premature announcement in the first 72 hours. And the Seventh Circuit said, well, you said it, they allege it, you'll have to work it out in discovery or motion practice. So there are real risks of either acting too quickly or waiting too long.
We had one publicized action by the California Attorney General against a company that had found that Social Security numbers of their employees were sold at a thrift store, and it took them a while to figure out where those came from. The investigation took 2.5 months or so. By the time they determined that the numbers were authentic and they were subject to a breach, they started notifying, and the California State AG came in on 17,200, your favorite statute, and said this was too long. The statute itself doesn't have that penalty. It just says you can ask for damages that you suffer, but you'd have to prove them in court. And in this case, it was a penalty based on unfair competition law that the California State AG was able to extract a settlement basically from the company.
And I think that really highlights that in order to limit liability, you really have to focus on the nuance. There you've got a statute that doesn't say anything about timeliness. But if you're practicing in the field, in the privacy and security area, you know that timeliness is an issue. And there are all these general principles that get borrowed from Federal Trade Commission, from other things, that then get applied. So this is not an area where there's just black letter law that you can focus on, except, of course, Lothar's book, A to Z.
When we think of the possible repercussions and a company saying, maybe I should notify just in case, so then I'm on the good side of the notification, Ian, what would you say? How likely is it that they're going to get sued over that?
It's an interesting question. There have been a number of instances where I've said, okay, you're going to get sued, and then it turns out they don't. or there's just a very minor lawsuit, and other times where what happens seems very trivial and there's a lawsuit. There are a number of factors that come into play. Obviously, you have to look at who the defendant is. If it's a big company, a deep pocket, you are more likely to get sued than if you're a startup company or you're a company that's just filed for bankruptcy. That's the practicality of it. Plaintiffs' lawyers are entrepreneurs of sorts, and so they're looking, where's the money? And so there's that element. Then you have to look at the type of breach. Is this something that you could not prevent? I mean, for example, actually, after this program began on my phone, I got a flash from the Wall Street Journal that they're going to bring a criminal prosecution against Russian hackers tied to the Russian government for the Yahoo security breach. So, something like that, foreign state actor. It's very hard for any company to prevent something like that from happening. Or is this something where you just were not minding the store? There are industry standards, and the company was not complying with those industry standards. The more that the plaintiffs can tell a case that would be sympathetic to a jury, the more likely it is you're going to get sued. But then there's also a bit of a herd mentality. One person files a lawsuit, gets a lot of publicity, you may have a lot of copycat cases. So you can't sort of rationally say this is what always happens. But those are the factors that you end up looking to.
A really bad time in any of these litigations is when the class gets certified. But has it become more difficult after Spokio and in light of the fact that not everybody is affected the same way by a data security breach?
That's a very good question, and it's also an area where there really is a split of authority. The Spokio case was an important U.S. Supreme Court decision from the last year dealing with standing. There have been a number of standing cases over the last couple of years. The Roberts Court loves federal jurisdiction. This is really like litigator's law. And anytime you have something that deals with federal court jurisdiction, the Roberts Court particularly likes it. There have been a number of 5-4 decisions generally tightening the standards for Spokio. And that was what was expected from Spokio. But then Justice Scalia went off to a remote part of Texas on a hunting trip, and it didn't end well. And you ended up with a 6-2 compromise decision, which gives a little bit of something to everyone in terms of standing. I think we are likely to see greater clarification. We're probably going to have a more conservative court, and there's nothing on the docket for this term, but I think maybe in 2018 or 2019, we may get again a further tightening. But right now, what you have essentially is almost a split of authority, because to get into federal court, you have to have Article III standing, which means you have to be able to show a concrete and particularized injury. What you have is that some courts adopt a more liberal view and some courts adopt a more conservative view. The predominant view in security breach cases is a liberal view that started here in Silicon Valley. Judge Lucy Coe in the Adobe case, and a judge in the Southern District of California in the Sony gaming case, looking at the earlier Clapper Supreme Court decision, which most courts around the country construed as tightening the requirements for standing. These courts said, well, it didn't really tighten the standards, it just used different language. So we're going to apply the pre-Clapper liberal Ninth Circuit law, which is if you have a fear or apprehension of future injury, you've not been a victim of identity theft, which is true in most of these class action cases, but you're fearful that you might. In the Ninth Circuit, that's enough. Now, that case was very influential in several district court cases. The Ramirez v. Neiman Marcus case, that involved one of the biggest security breaches. The Target breach was also the Neiman Marcus breach. And in that case, the Seventh Circuit said that the fact that Neiman Marcus provided credit monitoring services to class members was evidence that this was a very serious breach. Now, that's a problem because actually most companies were providing credit monitoring in the case of a breach as a way to try to argue against standing, because most of these cases are cases where there's no injury. If there's no injury, no economic injury, it's harder to establish standing. So the plaintiff's class action lawyers would say, sign up for credit monitoring, then you've got an out-of-pocket expense. And then, so the companies would offer this free of charge. The Seventh Circuit sort of turns that on its head and says, well, if you're offering credit monitoring, you wouldn't do it unless it's really serious. What it really means is if you are offering credit monitoring, you better put some nice language around that, making clear you don't think this is a serious breach, even though we don't think your information is going to be harmed. As a goodwill gesture, we're offering you this. But that view was then extended in the Lewert v. P.F. Chang case. That was the one I spoke about earlier, where it turned out there was no breach at all. But because they initially thought there was a breach and said there was a breach, there was standing. And then the Galleria v. Nationwide Mutual Insurance. But then just within the last month, the Fourth Circuit has taken a more conservative view, and the allegation that a data breach created an enhanced risk of future identity theft. That's not enough. That is too speculative to constitute injury in fact. Credit monitoring costs were insufficient to establish injury in fact. That's actually the polar opposite of the Neiman Marcus case. Neiman Marcus, the company, offered it, and the court said, well, that's evidence of a real harm. In Beck v. McDonald, the individuals purchased it themselves, and the Fourth Circuit said, well, because there wasn't really a substantial risk of harm, you didn't need to buy this, and the fact that you bought it doesn't bootstrap you into standing. So we've got a real split here. The reason that plaintiffs want to be in federal court is when you've got classes of people that don't have economic harm, you theoretically can get a better settlement if you have a large class nationwide as opposed to just a state class. But I think Spokio, to some extent, is forcing some class action lawyers to bring cases in state courts, and California is often the preferred venue for that.
And in California, no Article 3 standing requirement. Many of these privacy statutes have penalties associated with them. $500 per violation, $1,000 per violation, $3,000 violation that do not require any showing of any kind of harm. We all know that these harms that are supposed to be made whole with these penalties are usually made whole with coupons. 10% off the products, which the plaintiff's lawyers are happy to accept. But the threat of having to pay $500, $1,000, $3,000 per violation without any harm to be proven is something that companies take into account. Why do we get here? We were thinking about and asking about the question, should you notify just in case? I think the analysis for the company has to be, with the 47 data security breach laws now in the United States, is any one of them violated? Yes or no? That will probably mean, if it's a yes, you have to notify. If the answer is no, or not clear yet whether this or that has been met, then the company wants to think about, do people need to know to protect themselves? And if the answer to that is no, then some companies may decide rather not to notify, to not be sued for notifying when it wasn't necessary, or trigger all this rat's tail of class action lawsuits afterwards. Often
it's not a rat's tail. It's always a good time to litigate.
Often it's not really that helpful to consumers to be notified, because what are you going to do different? Especially with credit card information. So the credit card companies usually pick up most of the damage, and it is important for companies to think that through. Is it really worth going through that pain and suffering?
Yeah, let me add on that. If you don't have to give notice under state law, you may still want to, because if it ever comes out that there was a breach, if it put consumers in a position where they could be disadvantaged, then there might be a negligence or other claim. But as Lothar said, in many instances, the notice isn't going to do anything. And these notices are really invitations to state regulators, potentially the FTC, and class action lawyers to take a look at what you're doing. And so it's the kind of notice that if you don't have to send out, some companies may not want to do so.
An upgrade to the program is necessary because most companies here are doing business with Europe to some extent. And as of May 2018, you have the 72 hours, plus a definition of data security breach that involves any accidental destruction of data. I'm glad you didn't crash your computer there when Susan was recommending that and reboot, because that might have had a requirement to notify a bunch of data protection authorities in Europe for accidentally destroying some data. Now, moving on to another letter, we skipped quite a few here but online privacy is also one where we in California, in addition to some federal laws, can brag about a state law that since 2004 requires a privacy policy online. It's an operator of commercial websites and online services. Apps are included as well. And more Internet of Things and other offerings have some function where data is being collected from consumers. Who is protected under the California Online Privacy Protection Act? Any consumers in California. And the term personally identifiable information has a list of data categories here that are very ones that you would think of, but there is also one information concerning a user that the website or online service collects online and that would make the user identifiable from combination with an identifying the other option. So that gets very broad and does require fairly detailed notices. Also, it's only a enumerative list, and it doesn't say that it's completely exhaustive. We have some special rules for minors in California. There's a mini right to be forgotten, but it only requires companies to allow them to withdraw their own posts. It doesn't cover reposts or what other people write about minors, and it's not clear whether once they turn 18 whether they can still exercise it, probably for the time periods before. And there are some specific rules on collecting data from websites directed at minors for the purpose of marketing certain really bad products, such as tattoos, for example. If you market those, then you cannot collect information from minors on such websites. So there's some extra protections that have been creeping into this California statute. It applies to any operator of online service within or outside California. If you have a completely passive website that collects nothing, you're probably not under it because you're not collecting information from consumers. But even if you just have cookies, with today's technologies and the abilities of combining offline and online data, it's very easy to fall under that last seventh nebulous category of something that can be combined with an identifier. Data processors probably do not have to notify. So if your company just makes a service for other companies, I find it confusing then to have a privacy policy where you exactly describe how your product works. I think you have to describe where you're collecting data from the consumers in your own name on your own behalf. It is confusing if you then have another 50 pages of describing some products that you delivered to corporate users. The corporate users will have to disclose how they're collecting data from it. And you have some specific exceptions. One is for airlines, which was bad luck for our Attorney General, the last one, that she picked Delta as the first one to enforce this requirement to have an app policy. Now, Delta could have been a little more gracious and post one. How hard is that? But they were also able to rely on this Airline Deregulation Act not to have a privacy policy if they don't want to have one. You have to conspicuously post the privacy policy and then follow it, and enable minors to remove their posts. It's the how to comply with this. And the sanctions, you can bring actions, Attorney General, district attorneys, private parties, enforcement actions. We've had quite a few that are then linked to 17,200. There's a whole bunch of other laws that tie in with this, all other definitions of what personally identifiable information is, and no surprise, a lot of work for Ian on the litigation side.
Yeah, and the privacy cases are a little bit different from the security breach cases. First of all, in the security breach area, except for one recent settlement that was just publicized of $25 million, the dollar numbers on settlements in the security breach area have been reasonably low. Target, which was one of the biggest breaches ever, the consumer case was $10 million. Now, there's a lot of money at play in litigation following security breaches between banks and merchants or credit card companies over who has the actual risk of liability. But from these consumer class actions, they've not been big dollar numbers because you have the issue of standing. You have the issue of liability. Certainly in state court, you have these statutes that have statutory damages, but in a lot of these claims, you still need damage. You can't state a claim for breach of contract without damage. It's an element of the claim. And you also have causation. The Target breach was the Neiman Marcus breach. If your information was compromised, who's liable? So there are a lot of reasons why the dollar numbers have been lower. Privacy cases are premised not on your company being hacked, but on your company failing to do something, either affirmatively doing something that you shouldn't do, or negligently failing to not do something. The better class action lawyers actually have technologists on staff who do nothing but play with their phones all day, trying to figure out what's happening. And a lot of this circles around the advertising ecosystem. The first sort of wave of these cases really started about 2010 involving flash cookie litigation. And I represented some defendants in the first and second round of that, of those cases. And still to this day, a lot of the defendants in privacy cases are app and mobile providers, social networks or mobile providers, because there's some ID that ties you. So for example, if you look at this phone, you don't know this is Ian Ballin's phone, but you can tie this phone to certain searches, certain other activities. Advertisers get drawn into these cases. I've represented a number of advertisers that have done very little other than retain a reputable advertising company to engage in a campaign. Then sometimes they engage others. You really need to do your due diligence. You need to know who you're contracting with. You need to know what they're doing if you're contracting with others. But frankly, any company that collects information from consumers is potentially in there. The kind of claims that get brought are both federal and state. And as I mentioned before, the goal for a plaintiff's class action lawyer is to get from A to B, to get from filing a complaint to pass the motion to dismiss, because then there's some kernel of a case that they think will remain. The flip side strategy from a defense point is to knock the case out on a motion to dismiss or summary judgment, or if you have to defeat it on class certification. ECPA, the Electronic Communications Privacy Act, a federal statute, federal criminal statute. Title I is the Wiretap Act. Title II is the Stored Communications Act. Federal Computer Fraud and Abuse Act, we already talked about that. Video Privacy Protection Act, which we'll talk about in a little bit more detail. Then the common law claims, state law claims, breach of contract, breach of the duty of good faith and fair dealing, which could be breach of a privacy policy. Is your privacy policy something that defends your company or that can be used against you? To some extent, it's a statement of what you're doing, so if there's a variance, you could be sued for it. I think it's prudent in today's world, if you have privity of contract with potential plaintiffs, to include an arbitration provision. Not necessarily in the privacy policy. Make the privacy policy part of a terms of use or EULA, put an arbitration provision in there, and then if you get sued by a class action lawyer, the issue gets sent to arbitration, and it's an individual claim. And that's a totally different ballgame, different economics than if you have to defend a class action suit. California unfair competition law, we talked about that at the outset, Section 17200, thanks to Governor Schwarzenegger and a ballot initiative, you actually have to have economic harm. And so actually there have been a number of privacy cases under 17200 in recent years thrown out because they're lawsuits against internet companies or social networks that provide a free service, no out-of-pocket harm. But it's still very broad, even if there's a violation of a federal statute that doesn't allow a private cause of action. You can make it actionable under 17200. California Invasion of Privacy Act, California Consumer Legal Remedies Act. To be actionable, a plaintiff has to send you 30 days advance notice and an option to remediate. What it means to remediate in the privacy area is often unclear. Excuse me, California Constitution, Comprehensive Data Access and Fraud Act, Penal Code Section 502, and electronic trespass to chattels, a number of different causes of action. Common law privacy, let me just spend a quick second to really say common law privacy and California Constitution, the claims really focus on reasonable expectation of privacy. And this is an area where I think overall the California courts have been better than they have been in a lot of other areas of law in terms of what is reasonable or what isn't reasonable. But ultimately what's reasonable is up to a judge and jury. So if you, as a savvy privacy and security lawyer, think that a particular practice is reasonable, that doesn't necessarily mean that's what a judge or jury is going to say.
Besides those broader statutes, there's also very specific ones. Ian, you said you actually drafted this one, isn't that right?
I drafted this one? No, I did not draft this one, the Video Privacy Protection Act, but I lived in D.C. when it was enacted. I was living in D.C. This arose from the confirmation hearings of Judge Bork. Judge Bork was nominated to be a U.S. Supreme Court Justice by President Reagan. The Democrats who controlled the Senate believed that he was far too conservative. And this was one of the first times there was an all-out campaign to try to defeat a Supreme Court justice. I remember there was a full-page ad in the Washington Post essentially looking for dirt on Judge Bork to try to prevent him from being confirmed. There was an independent newspaper in Washington, D.C. that went to Judge Bork's local video rental store and asked if they could see his video rental records, and those were turned over. Now, for those of you under age 30, a video rental store was a place where you had to go to get a movie. In those days, we didn't have Netflix or Amazon or YouTube. You had to buy a movie or a video on big, clunky, tangible media, or you rented it from a rental store, which charged you late fees if you were derelict in returning it. These were very, very dark times, but thank God we have lived through them. Now, Judge Bork was an antitrust scholar, and his video rental records were not very interesting. He and his family rented a lot of movies about history. But I think the U.S. senators sitting on the Senate Judiciary Committee probably had much racier video rental records because they were shocked to find out that you could just walk into the video rental record store, ask for the records, and have them turned over. So at a time when there was no federal protection for the privacy of Social Security numbers, Congress, in its infinite wisdom, passed the Video Privacy Protection Act, an interesting little statute that now is getting litigated.
It's very specific. We have a matching one in California, a Reader Privacy Act. And since we're just on these new technologies, we also have one on the usage of voice-controlled smart televisions. We had a case recently, a federal case, settlement against a smart TV that was watching the viewers too much and undisclosed. But we have all these very specific statutes here, and these have, a number of companies got caught up in them by not completely following the consent requirements in the statute. This one doesn't just satisfy itself by destroying reasonable privacy expectations with the notice. It has a very specific requirement to get informed consent, either every time the company wants to share the video rental information, so real-time notices, or limited to 2 years. And if you don't do that, you just get consent once, as most services do, then after 2 years, that's not good enough anymore. Plus, a lot of companies were either relying on some implied consent or some description in a website privacy statement, which often is enough to negate reasonable privacy expectation, but not for this statute, which is very specific. Also, with the new services working all together, say in virtual reality headsets where you can watch with other people a movie at the same time, there's a lot more complicated scenarios, and to find out even who is sharing with whom and how is exactly the data streamed is not always so clear for all the players involved, which can trip them up. And there's a bunch of litigation that you've already listened to.
Yeah, there's been a lot of litigation. It actually started in California. I actually think there is an argument to be made that the VPPA doesn't even apply to online video players. I make that argument in my treatise, but that's not the way courts have ruled. There are a couple of important things to be aware of. There are some splits of authority among the circuits. This is an area, actually, where the Ninth Circuit has been reasonably measured, but the First Circuit has the most expansive view of the statute, which means if you're a plaintiff, you want to file suit in Boston. And if you're a company, you want to avoid litigation in the First Circuit, if at all possible. And the ways that it's broad have to do with who can sue and what is personal information. In terms of who can sue, the Ellis v. Cartoon Networks case from the 11th Circuit very reasonably said, if this is a free app, then you are not a subscriber and you cannot sue because the Act allows suits by subscribers. In the First Circuit case that I mentioned, which is the Yershov v. Gannett satellite case from the end of last year, or the middle of last year, the First Circuit said if you are a subscriber, excuse me, if you have an app on your phone, you are a subscriber. Now, that case was decided by two First Circuit judges and by retired U.S. Supreme Court Judge David Souter, sitting by designation. And Judge Souter was famous when he was on the bench for being what we might call a Luddite. He didn't own a computer. He was not tech savvy. I don't know if he owns a smartphone. But in this opinion, they said that if you have an app, you have enough of a connection to a company to be a subscriber. If I were to show you all the apps on my phone, I can point to some apps that I downloaded because they looked interesting and I've never used and I'm not even sure what they do. And that may be true of many people. I'm not sure it really makes you a subscriber, but it does in the First Circuit. The second area is what is personally identifiable information. And this is actually a problem for all California and all, frankly, American companies. What is PII? There isn't a common definition. Under different statutes, PII is defined differently. So under the Video Privacy Protection Act, in the First Circuit, they said a GPS coordinate is personally identifiable information. So this GPS coordinate, whatever it is here at Stanford Law School, knowing just that is personally identifiable information in the First Circuit. I think that's too broad. I don't think that's what Congress had in mind. All the courts agree that personally identifiable information under this statute is something that will identify a person even if it's not by name. So they may say, it wouldn't identify me as Ian Ballon, but it might identify this phone as a phone that has watched some particular video. On the other hand, the Third Circuit after that, they didn't say they disagreed with the First Circuit because then you'd have a circuit split which would justify cert to the U.S. Supreme Court. But they said, well, GPS coordinate maybe is different, but we think, at least in this context, the following elements are not PII. Frankly, I think things that are probably more significant than GPS: IP address, browser fingerprints, cookie identifiers, and unique device ID numbers. I mean, to me, knowing the ID number of this phone probably tells you more than just knowing the GPS location of Stanford Law School. We're all here in the same GPS location. But again, it really shows how what is or isn't personally identifiable information changes. And one of the underlying currents, it's not decided in these cases, but the underlying current is anonymized information can be repersonalized. This came up a number of years ago when all the healthcare information was released in Massachusetts, but they scrubbed the names. And just knowing the age, the race, and the sex of the governor, a researcher at MIT was able to say, this is Governor Weld's medical records. And this is the underlying issue. And it's not just under VPPA. There's a lot of anonymized data out there. Now, I think the better view is if it's anonymized, it's not personally identifiable information. But if it can be de-anonymized or repersonalized, is that actionable? And some plaintiffs' lawyers say yes, and under some statutes in the future it may be. But that's an underlying current. I mean, Lothar, what's your view of that when you're advising clients and they've got anonymized data, but it's data that could be repersonalized?
My view is that when this goes to court, I want Ian to be there every time. But before that, I would say to clients, anything that relates to one person, even if you take out all the identifier, I think when in doubt, I would always treat that as personally identifiable information. If you have the time and the luxury to go through all the different statutes, and again, in the book I have 15 different definitions just out of the civil code what personally identifiable information means, what that one term means. If you have the time to fully analyze this and conduct a privacy impact assessment and really satisfy yourself that you're outside, and you're also okay with the risk that you're swiped in with the California right to privacy on the constitutional level, maybe you get comfortable. But until then, and most of us don't have that time, the product is launched before you're able to conduct that assessment, I think it's better to assume it is personally identifiable and you comply with the requirements as if it were, because there are too many laws out there now and too many arguments out there that I think it's not worth it to even try this on the definitional level. For the most part, you have to get consent, you have to put notices out there, which I think is, for many reasons, preferable. That's my view on that particular topic. We have a few more of the letters. We also wanted to get to some of the practical stuff. So maybe on the wiretap one, we just remind everyone that here in California we have 2 or all-party consent requirements. It's not enough just to tell your employees that you're monitoring all information. You also have to tell people outside of your company. It may not be enough to just tell your service users that you're scanning emails for purposes of virus protection or putting advertisements in there. You may have to tell the other side as well. That is an important lecture that we've seen in a lot of litigation cases that you have out here. And for the additional fund that we have here is the Eavesdropping Act that was recently on a Ninth Circuit decision again. That is also on call recording that one party makes without telling the other party. That's why Stanford had you all sign these really long consents that I see in front of you. Otherwise, it wouldn't be okay that you're being taped here right now. So that's just the point on the wiretap law. We have another one here just for a happy letter. Your privacy rights is something that we all have to put in California privacy policies to comply with the statute that goes over 5 pages in the Civil Code, has a long list of things that you're supposed to do if you're sharing personally identifiable information, defined differently again with other companies for their direct marketing purposes, which you often can't rule out. We were talking earlier, Ian, why hasn't that one made it more to the courts where it has a penalty in the statute? But we have only seen a few cases, and they didn't go so far.
Yeah, it's interesting. You know, what happens is the class action lawyers focus on a particular technological practice or statute. They all swarm in. There was a point in time, I think it was around 2012, 2013, but there was a point in time when there were a lot of these cases. They didn't go so well, largely because there is essentially a safe harbor. If you do certain things as a company, you can avoid liability. There are statutory damage claims, but that, I think, a lot of the cases were knocked out on standing, and then the other ones just didn't get that far because it's a situation where you almost get like a one bite at the apple. If you made a mistake and you didn't do it properly, you have an ability to remediate before you're going to get subject to statutory damages.
Before we turn to some of the more general recommendations on privacy notices, privacy policies, just to see here in the audience whether anybody has questions by now. You've been awfully patient here in the evening to see our show here, which is already 20 past 8. Yes, please. I'll repeat the question. So the question is there still a lot of litigation pending over the Video Privacy Protection Act?
There have been a number of cases. Now, just within the last year and a half, many circuits have scaled those back, but not the First Circuit. But even just within the last couple of weeks, in the Vizio case in the Central District of California, the court denied a motion to dismiss, allowing a case to go forward, essentially following the First Circuit view. I represented a client in that case. We got out earlier. That also reminds me I need to give my disclaimer. Nothing I say represents the views of my clients or my law firm or even myself. These are all abstract principles intended to further continuing legal education. But I mean, even just within the last 2 weeks, we've had a decision in the statute. So I think the big circuit decisions from the 11th Circuit, from the 9th Circuit, from the 3rd Circuit are slowing it down. But the First Circuit decision still gives people a reason to file suit.
Some of the more general considerations that we also wanted to bring out here, if many of you are not going to court that much, I don't. And we have to still draft privacy statements, look at privacy programs, try and adjust them, not just for GDPR that everybody's so excited about, the new European law. I mean, after 25 years, they updated their law. That's good. In the meantime, we've passed 5, 6 laws here all the time, and we have much greater litigation risk here. So one of the questions that I think you should all think about is when you put a privacy policy in place, are you describing really what the person person who's reading that needs to know? Are these the disclosures that somebody needs to know? One of the things I see, a lot of you make services for other companies to use. On your website, you have to give some disclosures to consumers who are accessing your site to learn something about your product, if that's what you make, consumer products. If you're B2B, you probably wouldn't have to give any privacy notice, or really a short one that wouldn't be dictated by statute what you tell the employees of your corporate customers or suppliers. But if you are putting a little website privacy statement together, it probably fits on a couple of pages and doesn't have to be 30 pages long and describing all your products and what all your products do. We've had in a number of cases where companies that make services for others were making representations on how these products work and how they function, but that would really be for the users of those services to make, and they were not always true. One company was forced into settlement that had said on its website that everybody could opt out of the service, but their customers could also configure it in a way that an opt-out was not possible, and this contradiction was found to be unfair competition by the FTC. So I think it'd be important, as you put a privacy notice together that is for the external world, that you think about where you place it, whether that really reaches the people for whom you drafted, and not just try everything privacy related in one big document.
And I think this goes without saying, but in addition to the statutes that you need to look at the case law, what are the trends from litigation, and look at the regulatory enforcement issues. The Federal Trade Commission has been very active in this area, and if you look at their consent judgments, that tells you where things are going, how you can get in trouble. And of course, the California Attorney General. Many state attorneys general are the AG acronym also means aspiring governor, or I guess in our case, senator. Kamala Harris was very active in this area. She's now a U.S. senator. Remains to be seen how aggressive the new attorney general will be in this area. But it's certainly something to look for, particularly in California, because Kamala Harris really led the country for a while in privacy and security enforcement. And so it's not just the black letter law. You really have to understand the nuance and the trends where it's all going.
Another question is, should you do combined notices where you address your requirements, say, under HIPAA versus for patients, and then for website visitors, you put something else in there? Maybe if you have some segments of your site that are dedicated to children, are you going to try and put that all in one big document, or are you going to split it up somehow and address people? I think in the past, where privacy policies were designed mostly on best practices, it was possible to have one mega notice that would address the most important points. But I think we're seeing so many very specific requirements, form requirements on how notices have to be drafted up, that I think in the future we'll see both, maybe one general statement and then all these very specific ones. Hey, if you're European, click here for our Privacy Shield notice, which has to be organized in a certain way under this very formalistic remake of the Safe Harbor program. If you're a patient, look here for our HIPAA disclosures that are organized differently, again, have references to different statutes. I think the future will unfortunately have more of those notices geared towards satisfying very specific requirements. Under this California Shine the Light law, you have to say your California privacy rights. Under the CalOpGA, you have to list the categories of third parties with whom the operator may share personal data. We often see very, very general statements and privacy statements such as trusted business partners. Ian, what do you think of that? Is that a good disclosure to tell people what the categories of third parties are?
Categories, yes. I don't know what a trusted business advisor is. I mean, we were discussing this earlier. If you say someone's trusted, does that mean they're vetted? There's a lot of tensions with these policies, because if they're too short and abbreviated, you run the risk of omitting a disclosure, and then that's a problem. If it's too long, then a court is going to say, well, a reasonable consumer isn't going to understand it, because yes, you clearly said that the personal information will be sold to Russian hackers, but it's on page 37 of your privacy policy, and no one is going to read that far. And so there's a real tension. The FTC a couple of years ago said, well, you should have tiers, like you put the important stuff first, and then you can click back for more detail. As a litigator, I think that's a terrible idea, because then you're going to have endless disputes over, well, this was not in the front, this was in the back. So then you're saying it's not important. It should have been more prominent. Again, it's one of those things where unless it comes with a safe harbor to avoid litigation, it's one of these things where the government is saying something that you should do something that makes theoretically good sense, but it's going to lead to greater liability in litigation.
Under the Article 12 of this GDPR that I mentioned a couple of times, the new European law, there is also a requirement to keep it plain and simple. And then in 2 other sections, there's a long list of information that has to be provided. It will be difficult to satisfy that without going really through these formalistic steps. And I think if you were going through those, you wouldn't satisfy the plain language requirements here in California anymore. So I think ultimately you will have to probably do separate notices addressing different regulators and writing it in the specific requirements that they demand. And I don't really see much harmonization over there.
Now, again, different notices for different geographic areas are a little bit easier to implement, because then by IP address or by domain name you can target it. What's more challenging is when the laws are creating different tensions, where you need to be longer, you need to be shorter. It's all for a U.S. audience, and then they're difficult balancing questions you have to come up with.
You also have to make decisions as new requests for disclosures are added. We had one here in California a couple of years ago that you have to say how you respond to do not track signals. And I remember there were a lot of clients that wanted to say something upbeat and positive about this and said that they care about the privacy, but they don't really know what tracking means, and put like long paragraphs in there, until some of them, after a few months later, just started writing in there, we're trying to give you a customized experience, and we do not currently respond to do not track signals. Nothing really happened. And I think the companies were trying to say something more positive or limited, and they were just setting themselves up for possible claims that they were misleading people, or was unfair, or was unclear what exactly they were doing. It's a fact that the internet doesn't work without tracking, right? In order to have a session with somebody that is really created by browser calls, unless you put cookies there and remember a little bit what the user told you the last time, you can't respond in a very good user experience way. So some tracking has to go on, and that's not really what the drafter of the statutes had in mind. And so the question is, with each one of those, where are you going to go to try and address those things? Are you trying to sugarcoat? We were discussing this a little earlier. My sense is you're not selling your product or your company in the privacy policy. I think you keep it short and put facts in there is the better way to go. There is no upside that I see to saying your privacy is very important to me, or we have state-of-the-art security measures implemented. I think that is only going to be read by regulators when you had a problem with something and then hold against you.
I think it's a balancing act, because it really depends on a number of factors. But for example, many years ago I represented a company, and they had a fairly innocuous generic statement in their terms of use that every other company had that didn't really mean anything nefarious. But someone actually read the terms of use. Which, of course, we always discourage that. No, I'm just kidding. But someone actually read it, and they posted this blog post saying this involved MySpace, and they said, well, Rupert Murdoch is trying to get your personal information, and here's why. And that's not even what the provision meant. But that's the one danger, which is, Lothar is correct that from a legal standpoint, I think you just the facts. But from a public relations standpoint, sometimes you have to sugarcoat it a little bit, because some people will read it, and some people will not only read it, but they'll blog about it. It depends what kind of company you are. If you're a kind of company where, if you're in the gaming industry, gamers have too much time on their hands. They will read it. They'll try to figure out what it means. They're not legally trained. You need to put some flowery language. I would never say, though, privacy is very important to us, well, I shouldn't say that. Some courts will recognize puffery as not being actionable. So if you say, privacy is important to us, that's not really saying anything. But if you say, we take strong measures to protect your privacy, that's a representation, that's a warranty. And so it's a careful balancing. You have to be careful how you present it.
At a minimum, I think write it up once, honestly, for yourself and for your management. Say, this is really what we want to do, and see if they're happy with it. If they then say, oh, we can't tell anybody that's what we want to do, then maybe don't do it, And if you still want to go ahead and do it, then maybe the balancing act will start with a clear disclosure on what the risks involved are. I think it is helpful to draft it in plain language once for the company to see and compare to the values what exactly they want to do, and tell it how it is and how it will be probably told in a complaint later.
And one caveat, though, like you can't fully disclaim things. Certainly in the privacy area, you can say, you know, we will sell your information, you know, to hackers in Eastern Europe, and as long as it's true and it's fully disclosed, you know, then people have an opportunity. But in the security area, you cannot fully disclaim it. One company tried to do that, and if you say, we do not represent that we provide any security at all, the internet is insecure, anything on the internet can be hacked, the FTC will consider that to be unfair, that it's unfair within their jurisdiction of unfair or deceptiveness, because they have construed that a company on the internet has to at least take reasonable protections for security. So again, this is part of the balancing you have to consider.
We have a few formulation recommendations here. We also have a few checklists for you that we sent out with the invitation, and we'd be happy to answer more questions if anybody has any right now.
Yeah, and I've included some excerpts from my treatise talking about litigation trends for privacy and security, and then also talking about security breach notification laws, just if you have trouble sleeping, print it out and read it late at night. The presentation will be available. It is currently not available, but Roland, we can
send it out to all registered.
Please don't cite it in any briefs.
So the question is, thinking of how much data these headsets are throwing off with virtual reality, where you have to really communicate with the platform. Any of you have enjoyed one of those headsets, you can turn around and you see the dinosaurs are attacking you from all sides. And whoever provides that experience to you will have to know that you just turned your head. So they have to monitor this and they have to process that. And I haven't seen any privacy litigation. I would be disappointed in our bar if they weren't bringing some claims. I think the answer to this is very clear disclosures on how much data these systems have to collect and have to throw off, and really plan through it. Any of these new platforms that will process video content and other things have to think about various different statutes, and it will be very complex to do so. But I haven't seen any privacy-related suit yet.
I haven't seen the suits, but there definitely are issues because, for example, if you're playing virtual reality games and if the information is being tracked, then there might be things like the fact that you're blind in one eye, or that your hearing in one ear is better than the other, that may be tracked. Now, that's not health information under HIPAA, but that's certainly personal information. And so there are issues where, again, transparency and disclosure is the best way to deal with it, but it's not filtered to courts yet.
So for email, think about what we discussed here is mostly around web notifications. Do you think that's sufficient to cover counterparties who are receiving such email privacy expectations they may have, or does it require us to put something in
So the question is from email communications, what kind of disclosures are required? I would say that somebody who is responding to emails or accepting emails is not providing an online service under the California Online Privacy Protection Act. And the way email works is the consumer sends it to you, we respond back. I'm not sure how many disclosures would be required for the basic email. Where it becomes more interesting is that more and more companies want to know whether you open your email, how many times you scroll through, if you're forwarding it to people. That kind of technology would get pretty close to accessing somebody else's computer without authorization and would probably require some disclosures. Now, you can set your computer settings to allow this or not allow this, depending on what browsers and what email program you use. So depending on who you're communicating with and how you set these tracking computer programs, maybe you don't have to provide extra notices. But I think in general, the more you add on to your emails, for example, you put clear pixels in there that will make a web call. Sometimes we do that. I think law firms do that too, in order to show pictures without having to email them and clog the mailbox of people. Only if they open it up, the web browser will make the call and show the picture. But if you put a clear pixel in there just to generate that call so that you're notified whether somebody's reading your email, I think that probably exceeds what is totally acceptable, depending on how the browser and the email box setting on the other side are. If you set your mailbox to allow this generally, then perhaps a specific notice would not be required. In the B2B setting, I don't think a special notice would be required. Corporate law firm talking to corporate clients, I don't think that would be required. Somebody talking to consumers, children, knowing where they open this, how many times, might require some disclosures or even prior consent.
There are no more questions. We're already a little bit over our time, but please join me in thanking our speakers for
Oh, it's a fun.